Good afternoon all, and welcome to this webinar, Off-Payroll Working Rules in the Private Sector, or what you need to know about IR35. We'll give it a minute to allow everyone to connect, and in the meantime, you'll see on your screen a poll question which we'd like you to answer, please, if you will. This will give us an opportunity to gauge the level of understanding, and we'll check again at the end to ensure that the session's been effective. If you have any questions as we go through the session, please send them via the question and answer button at the bottom of your screen, and we'll answer as many of these as possible at the end. We will be recording this session, so hopefully you'll be able to go back and visit anything you wish anyway. Okay, I can see many of you have responded there, so I think we are ready to go. So, welcome to today's webinar, brought to you by JMW, a top 100 law firm based in the northwestern London for more than 40 years, and the Giant Group, a leading workforce management services company for 30 years. Our subject today is off-payroll working rules in the private sector. The purpose of the event then is to firstly make you aware of the changed responsibilities for all parties under the revised rules, then to describe the potential implications in terms of the risks and the costs, and finally to outline the options to address these requirements. Our keynote speakers and legal experts today are firstly Sue Ollerenshaw, who is a director of Efficient Tax Solutions, which provides personalised, practical and tailored solutions. Her mission is to ensure that clients understand and comply with their PAYE, National Insurance Contribution and CIS obligations, and obviously ensuring they don't pay any more than they should. From JMW, we have Simon Block, who is an employment partner with specific expertise in working with clients in the recruitment sector since 2007. Simon has worked with a number of recruitment trade associations and regularly assists businesses to put in place compliant contractual terms. Our practical implementation expert today is from Giant. It's Dan Haslam, who is the Group Sales Director, and his role includes helping clients to manage their contingent workforce compliantly and cost effectively using the whole range of Giant's services and products. I'm David Hopkins, a workforce management consultant with Giant, and I'll be the chairperson for this session. The format today will be based on a number of questions which Sue, Simon and Dan will address to give us a full view from a legal and practical perspective. There'll be an opportunity to ask questions, as I said, at the end, so please submit them through as we go through the formal session and we'll pick them up. And just a couple of points to make before we start. Those of you who haven't, please complete that poll question for us. And then to say we are broadcasting remotely today, so apologies in advance for any sound or technical issues. I think we're good at the moment, so let's hope we stay that way. So let us begin. Sue, if I may start with you, would you please remind us briefly, what is IR35 and what changes does it bring that might affect those who utilise off-payroll workers?
Thank you. Well, IR35 was actually the number of the original press release going back to 2000. The idea behind this legislation is that if the terms and conditions under which somebody is operating are broadly similar to an employee, then they should be taxed as an employee. When the legislation was initially introduced, the onus was on the contractor's intermediary to determine whether or not PAYE and NIC should be applied. The new rules actually switched that onus from the intermediary to the end user client to try and increase compliance. Now, you need to bear in mind that this isn't the only piece of legislation that could be affecting the people attending, and they do need to look at different pieces of legislation in specific order. So currently, if you've got a direct engagement, you would look at whether or not the terms and conditions are employed or self-employed, and that would normally mean that PAYE is due if the relationship is employed. However, operating in this sector, somebody can be self-employed but deemed to be receiving employment income under the agency worker rules, where there is actually targeted anti-avoidance rules to prevent abuse. Currently, then you need to look at managed service company legislation, and only then would you look to IR35. And finally, if none of those apply, and if you're in construction or a deemed contractor, then you would look at the CIS rules. The priority is changing from April, so that IR35 will now take priority over the MSC rules, and IR35 still takes priority over CIS.
Okay, so in the employer now has to determine the employment status of the workers, and once that determination has been made by the end user, what then become the obligations on the fee payer?
The fee payer is responsible for deducting PAYE and national insurance from a deemed payment, and for accounting to HMRC for the employer's national insurance liability, and if relevant, the apprentice levy. What they're not liable for is any statutory payments, national minimum wage, pension contributions, or holiday pay. They do also have an obligation to make sure that if they are, as part of the supply chain, depending upon where in the chain they are, they do need to check that whoever they're contracting with hasn't got any history of abuse.
Yeah, okay. Yeah, which probably brings us to another point, because we've heard quite a few times the expression reasonable care. It's mentioned frequently in the context of assessments and managing the supply chain and making sure HMRC receive due deductions. So what do HMRC consider is taking reasonable care?
Well, it does depend upon the size and the back office support of an individual organisation. The revenue will be looking for a higher level of compliance from a major PLC than they would be looking for from a smaller company, to the extent that they are obviously caught by these rules. They've said categorically that making blanket decisions rather than looking at specific individual cases and circumstances would not be taking reasonable care. They've said that it's important that whoever makes the decision has the correct level of knowledge and understanding, that people are given reasonable training, and that their actions would be seen to be those taken by a prudent and reasonable person. There is an onus to keep records and to also to seek appropriate advice.
Yeah, okay. Yeah, and I think one of the big issues of this change really is about the risk that there is now for end users. So in terms of liability then, let's say that they've done the SDS correctly, but there ends up being unpaid PAYE and national insurance. Who could be liable in that event?
Well, the liability passes from the client down the chain until it reaches the fee payer. If the fee payer defaults, then the liability goes back up to agency one if there's more than one agency in the supply chain, or if there isn't an agency, then it would go back to the client. Now there is the defence of reasonable care specifically in this legislation for the client. Unfortunately, that doesn't apply to the fee payer. However, there are other pay-as-you-earn provisions that a fee payer may be able to use to actually avoid the liability resting there. There's some quite draconian transfer of liability rules if the fee payer does go down, and a lot of that is based on revenue interpretation rather than specifically being in the legislation.
Yeah, okay. Okay, and one last question for now then, Sue. There's been a lot of talk about a PEO model, professional employer organisation model. Can you explain what that is for us, please?
Well, I think broadly there are two models, The first model is what we tend to refer to as the vanilla model, which broadly is a rebranding of how umbrellas work currently, potentially with more benefits. The other model that's being pushed quite aggressively, and I will at this point say I'm not a VAT expert, but the idea behind it is to avoid VAT by having a joint employer. So there's a joint venture company set up. Now, in theory, that there is specific legislation to provide for this arrangement, but in normal circumstances, there would be some genuine connection between the two businesses. And with most things involving any planning arrangement, the problem is in the implementation. I am aware that the Revenue have issued non-statutory clearances on the VAT point, but that's been based on documentation provided. And when it's been tested in practice, what the Revenue were told and what's actually happened hasn't been the same thing. And as a result, the person entering into these arrangements could be responsible not only for additional VAT, but for any underpaid PAYE and national insurance.
Yeah, okay. Right, okay, well, thanks, Sue. That I think gives us a good insight into some of the obligations and assessments and risks that we need to be thinking about. So now I'd like to turn to Simon and focus on the employment law and rights issues involved with the various parties. Simon, Sue introduced us there to the PEO model. So first question to you is, what employment law changes or challenges are presented by PEO?
Yeah, no, thanks, David. Yeah, PEO is a relatively newish concept in terms of English employment law. It has been out there in terms of some commentaries that I've read for a number of years, but it's not really come into the forefront of English employment law. I think the main reason for that is because traditionally employment law relationships have flowed from master and servant type relationships. So the difficulty with these PEO models is that you're expecting somebody to be jointly employed by two bodies effectively. And therefore you would have to say that if there's going to be two employers, you've effectively got to be in it together. And when you're starting to talk about how it works in practice and the contractual documentation, is actually you've got to be making sure that what you're documenting does actually reflect what is going to happen in practice. That's really important when you're putting in place a contractual document such as an employment contract, that it works as it says it does on the tin. Just a couple of examples of points that you're going to have to think about if you're looking to use one of these PEO type models. So the issues would be everyday management, who's going to be responsible for what the employee does, and directing them, agreeing what the applicable terms and conditions are, such as sick pay, annual leave, where they're going to differ between the various different employers, deciding who's going to take on responsibility for dealing with grievances and management of disciplinary processes and making decisions on those sorts of things. And then if you wind up in employment tribunal proceedings, who's going to be liable? These are really serious issues that you're going to have to think about when you put in place, or if you would like to put in place a PEO model. So it's not all plain sailing, and it's not, I would say, something that is clearly recognised or been tested within employment law in the tribunals.
Simon, I was just going to quickly add into that. I think, as Sue said, there's a vanilla flavour of PEO, and then there's this co-employment model, which is a little bit is what we're focused on there in terms of very, very unclear and untested. You know, the vanilla flavours would tend to be very clear. There would be one employer of record, very similar to Umbrella in that respect. So I would assume that would be a lot more straightforward.
Yeah, absolutely. Yeah. You don't have the same problem with the vanilla type model, because it's quite clear who the employer is, focusing more on this second model where there's joint employment. That's where we get into a lot more dangerous territory.
It really needs testing, doesn't it?
Yeah, absolutely.
Okay, well, I think we'll probably visit this a bit more when we come into a couple of questions for Dan. But looking at employment rights, Simon, what are the differences for employees, workers, and those with a self-employed status, and why are they important in this whole context?
Yeah. So just to try and put some information down there, there are 3 different categories in employment law. You've got employee status, worker status, and self-employed independent contractor status, which is where there's a mismatch with tax law, because there are only 2 statuses, as I understand. So in terms of when you're classed as an employee, you have an employment contract with your employer. That's made when you accept the job. You tend to have regular work. You're employed to do the work personally, and you must do the work. You then, as an employee, you'll have particular employment rights. You'll have entitlements to minimum sick pay, holiday pay, parental leave, and also the ability to claim unfair dismissal and redundancy rights. So that gives basically the traditional employee status. There's another status, this hybrid type status of a worker. If your employment is a bit more casual and you're engaged on what is known as a contract for services, that's to do or provide work services personally in respect of you get a payment or reward for that. There's no real obligation on you to accept that work. For example, you get 0 hours contract workers where you're offered work as and when. You don't have to accept it. And you do have some minimum rights with that sort of status, such as minimum rights to minimum wage, holiday pay, protection against discrimination, whistleblowing. They're just some of the key main rights. And the final status, where you're traditionally self-employed, when you're responsible for when you do the work. You may own a company, you may be a freelancer, you invoice for the work that you do, and you get contracts to provide work services for clients. You're able to send substitutes to be able to do that work. You can charge different fees, but you don't get really any type of rights with that self-employed status. There'll be no holiday pay, no sick pay, and it's really quite limited as a self-employed individual. So that just sets out the 3 different rights, three different statuses that you would have in employment law. Yeah.
Okay. Now, one of the big initiatives of the last year, 18 months or so ago, was the Matthew Taylor report and the Good Work Plan. So what impacts does that have on employment status, do we think, going forward?
Yeah. So status has been really quite a hot topic over the last few years, which has been driven really by three different things, I think. A need for greater flexibility in the workforce, which has been driven on both sides by both employers and individuals, leading to a far greater number of people wanting to work on a self-employed type basis. But that's been then followed by a reduction in tax revenue if people are self-employed, and also the gig economy, which we'll have all heard about, which has tended to categorize individuals as being self-employed with minimal regard for long-standing status type rules. As you've said, employment status was one of the key areas that was looked at under the Taylor Review, and was subject to a standalone consultation under the Good Work Plan in February 2018. And what the Taylor report proposed was that the definition of worker needed to be a lot clearer and more consistent, and that workers who were not employees should be renamed in the legislation as dependent contractors. It also proposed that there should be a less emphasis on personal service and more emphasis on control and defining the relationship between an employer and a dependent contractor. And what the government has agreed is that they've agreed in principle with Matthew Taylor's report, that having different types of status tests for tax status and employment law has led to uncertainty, and it has said that it has plans to reduce those differences to an absolute minimum. The problem that we've got with the report is it doesn't really state how it's proposed to address those fundamental differences between the two systems. So for the minute, the Good Work Plan really hasn't dealt with how it's proposing to implement those changes. I think the positive that we can take from it at the minute is that they've acknowledged that there is an issue and that it really needs to be addressed, but we don't have any firm proposal at this moment in time as to how they're going to do it. There's some commentary and commentators out there to say you could change things within burden of proof provisions in the employment tribunal and assuming people are workers unless proved otherwise. But that's just commentators commenting. There isn't anything firmly out there, but it really is something that is on the radar and will keep continuing to come up.
Yep, I think you're right, absolutely. Okay, so thank you for the moment, Simon. Some important points there to ponder, but I'd now like to turn to Dan to give us your observations on what happened in the dry run we had this March. How did the end user clients react, and what behaviours did we see from contractors?
Thanks, David, and good afternoon, everybody. Yeah, I suppose that's one of the the benefits of the postponement that we had back in March, is that we got a real good dry run, so to speak, to see how hirers were looking at implementing the rules and how they'd react. So I think it's useful to sort of look over that and share some of those observations. From a hirer's perspective, I think a lot of them had to make a key decision at the beginning, which is actually, are we comfortable with the potential risk here that this might pose to us? As you know, as Sue's covered off, there's certainly some tax risk around this now in the event of non-compliance through the supply chain. And for some hirers, their risk appetite was extremely low, and a number of them made a decision just not to operate having any personal service companies in their supply chain. The examples that are most commonly known are probably, excuse me, the banks, the financial or the financial institutions made decisions to say, actually, this is complex. We're going to make a decision to say we're not going to engage people via limited companies anymore. Benefits for them on that, excuse me, is that they would therefore not have to do any assessments. So if they're making a decision just not to engage people in limited companies, there's no need to do assessments and status determinations. What it does do, though, is present different challenges, because that sort of move was met with a huge amount of resistance from contractors within those banks. You know, they didn't want to be forced to use umbrella companies or forced to go PAYE. They were keen to make sure they retained the limited company and were paid in that way. So that's one particular behaviour that we saw. My understanding from looking at the market and how it's currently shaping up, I think there'll still be a number of other hirers that are going to go down that road as well. COVID certainly eaten into a lot of people's time and is probably the main focus for everyone at the moment. IR35 is a project which they're probably getting onto the radar for the hirers in Q1 of next year, and that starts to reduce the amount of time that a hirer might look to do full assessment. So there's certainly going to be a chunk of clients that will go that way. We also saw some hirers looking at saying, okay, we're happy for companies or contractors to use umbrella companies moving forward, but what we want to do is dictate specifically who those companies are. That's really to ensure that they're not opening themselves up to other risks around supply chain compliance, especially making sure that the umbrella companies that they've got in their supply chain are compliant, they are financially stable and secure, and they've got a good reputation in the market. It's extremely important that be the case. That reduces potential risk back up the supply chain to the hirer. I think as well, there's obviously a number of hirers who were keen to explore looking at an assessment approach. There are a number of different assessment tools that are out there in the market. HMRC have got their own check employment status tool, or status for tax tool, which they've been promoting, which I would always direct a hirer to look at that in first instance, but it's very heavily criticised also, and tends to on the side of caution and make people look potentially caught by IR35, because it doesn't cover off some of the key pieces like mutuality of obligation, for example. The other tools that are in the market, not HMRC's own, but just independently out there, potentially offer a more robust approach, covering off mutuality of obligation, and some of them come with insurances as well, which some hirers have certainly been considering. But I think in the main, it's the risk which dictates the decisions to the hirer. They're considering the reputational risk and compliance risk and the battle with HMRC versus financial, the impact financially that it could have by deeming everyone to be inside or doing a ban on PSCs, because that has some financial consequences, and ultimately hirers need to be really assured that the projects that they brought the contractors in to do in the first place are going to continue uninterrupted. So I think that's certainly something to be considered. I think also as well, from a contractor perspective, they will shop around and look for the sort of best offering that they can get, which is often focused on a sort of take-home pay. Hopefully there's a lot of awareness in the market now around, rogue payroll providers that offer too good to be true take-home pays of 90% plus. But unfortunately, we do see contractors sort of investigating those options. But there's been plenty of work from HMRC to sort of tighten the loop on that now, and a lot of contractors are seeing notices coming through and letters where HMRC have actually deemed them to be involved with a non-compliant provider, and that's got some pretty big repercussions from a backdated tax perspective. So I think where hirers can, and recruiters for that matter, direct contractors to use PSLs or payroll providers where they've done the due diligence, I think that's definitely the way forward. Contractors are also quite anxious about wanting to know their IR35 status quickly. They'll be keen to understand that, so they understand what the cost implications are. So I think a hirer who's looking at an assessment approach will be looking at trying to make those decisions over the next probably 2 months. Those decisions really need to be getting fed back to the contractors and to the recruiters if they're involved as soon as possible. So because there may be assignment rate conversations to take place from there. But I think the other thing to say from a contractor perspective as well, whilst there's been a lot of noise around IR35, it's still a surprise to many of us in the sector how much of a sort of oblivious to the risks a contractor can be of operating in that limited company. It may not have been fully explained to them in the first instance, but it's now coming to light. They're fully appreciating that there is certainly some tax risks to them individually operating that way. So still a lot of awareness to be done, and people to be made aware of the challenges that are out there.
Yeah, and I think one of the inevitabilities of this whole process seems to be that there will be a big shift in status for those contractors who are currently operating from outside IR35 to inside IR35, which means they're going to have to be paid differently.
Yes, absolutely. Everything's broken up there.
Apparently.
Your connection just let you down a little bit there, Dave. I think the question was, does there need to be consideration around future payroll options if people are deemed inside, which is certainly the case. We've already mentioned PEO a couple of times there, so I think that's nothing more than a very simple PAYE option for businesses to use that would be managed separately to their own PAYE population. So we engage with clients that have looked to bring that solution in place. So they'll offer a straightforward PAYE arrangement to their contractors, and that's a sort of managed payroll that's separate to them just looking at taking them on their own books permanently. And that's both recruitment businesses as well as hirers directly. I think the uptake on the PEO model will be slow, but we can see it's gathering a head of steam in the market. I think the go-to solution for everyone, in the immediacy of next year, will absolutely be the umbrella model. Simon talked through some of the really interesting clashes that are going on at the moment in terms of employment status and position versus tax, and what an umbrella company should do if it's operating as a vanilla umbrella company is give workers employment status which matches the way that they're being taxed as an employee as well. So I think you'll find some contractors keen to make sure, if I'm going to pay tax like an employee, I may as well have all the sort of employment rights and benefits of that, such as pension, holiday pay, and the statutory payments. The other interesting thing with umbrella is that it is relatively established now in the market, and so therefore it's easy. You know, a lot of recruitment businesses have umbrella PSLs in place now, so that's something that should be easy as a switch to. It will be the volume solution. I think we were seeing in March probably about 70% of contractors who were deemed to be inside or told they could no longer use a limited company will go down that road. There are also payroll models out there that operate what's called a deemed payment arrangement, and that's where the contractor could be deemed to be inside IR35, but still actually paid through to their limited company. And in those arrangements, then the tax is deducted that is now deemed to be due, because this is an employment or an inside IR35 arrangement. So employers' costs are deducted and paid off to HMRC by the fee payer. The amount that's then left over is then paid, is then calculated PAYE and an employee's national insurance, which is again paid over to HMRC on behalf of that individual contractor as a payment on account, and the net is then paid over to the existing PSC limited company bank account, and then the contractor then does a self-assessment in the normal way. And we have seen that there's been a number of workers that have been keen to continue the use of that limited company, because IR35 does look at an assignment by assignment basis. So they may well have an assignment with one hirer that's caught, they have other work outside of that that is outside, and just for continuity, they wish to continue to still get paid through that limited company. So that model's okay. You just need to make sure that if you're doing it yourselves, you understand your own software for payroll, and that the payroll can handle making those tax deductions and book paying off to limited companies. And if you're looking to look to outsource that to a third party, then again, you need to make sure that fee payer is absolutely doing what they should be doing, deducting the right levels of tax and paying off to HMRC. So there should be a bit of due diligence done there. And one starting point and tip of advice that I give for everybody here is that you should absolutely think about the FCSA as a starting point. That's the Freelancer Contractor Services Association, which is a trade body of payroll companies that offer these services, and they have to go through very stringent tests, financial tests, as well as audits from the likes of EY, to actually ensure that they do what they say on the tin and deduct the right levels of tax, and that money does find its way through to HMRC. So there's going to be a variety of payroll options out there. The umbrella market is got lots of different types of behaviour within it, so you really want to make sure that you're picking a trusted partner, and I'd strongly suggest FCSA is a great starting point for that.
Okay, good. Thanks, Dan, and thanks to all our speakers for your responses so far. We have received a number of great questions from the audience, which I'd like to address now. And just before we do that, here's the acid test. Perhaps you can re-answer that poll question for us, which is coming up on our screen again now. Let's see if we've been able to move any of you up or down the scale. So while you're answering that, then let me just pick up on a few of the questions that we've had. And I think this one is for you, Simon, and it is, why are employment status cases subject to so much litigation?
Yes, okay. So employment status cases are not new, but what's really happened is the emphasis has changed now. First cases, when they were first brought out, they were largely focused on whether whether an individual was an employee or a worker. But now tribunals, what they're being asked is to look at whether someone who has been engaged on a purported self-employment basis are in fact a worker. And the difficulty with the worker test is that it has evolved largely as a result of case law, and it depends on the facts of each case, which has produced some inconsistent results, making it quite difficult to know whether anybody is truly self-employed. And the lack of certainty has been identified as one of the weaknesses in the current framework for classifying individuals who provide those services. What has happened with the run of legal challenges on employment status has highlighted that there is a significant risk that individuals who are engaged on a purported self-employed basis may actually turn out to be workers. And as I've said already, and we've highlighted, it entitles them to a number of things, into a number of employment rights, which include minimum wage, paid holiday, rest breaks on working time, the right to seek trade union recognition, and whistleblowing protection. And where this has been hugely challenged has been in the gig economy sector. And many of you will be aware of some of the high profile cases that we've seen in this sector. We've seen the Uber case of the drivers who were claiming that they were actually workers rather than being self-employed, and that has now gone up to the Supreme Court, and we're awaiting a judgment on that. There's been cases involving City Sprint and Deliveroo, but it's not just drivers and gig economy workers, couriers, for example, who have been affected by those cases. There are a number of other cases that have been considered in the last year or so, which have identified that this is a problem and status has been challenged. And the cases have gone either way. For example, there was a bunch of freelance art educators who went to the employment tribunal. I think there was about nearly 30 of them in total, and they were found all to be workers. But there have been cases, for example, that have been considered in the medical sector as well. One particular case that caught my eye when we were preparing for this event was a case, and I'll give you the name now, Community-Based Care Health and Narayan, which was 2018 case, which went up to the Employment Appeal Tribunal. And the doctor in this case was registered through her own limited company, and she was effectively a locum. And what happened in this particular case was that some of the factors of the case were that she provided her own medical equipment. She didn't need permission to undertake work outside of the work that she was doing in this particular assignment. She didn't wear their uniform. She'd worked for, she didn't have any obligation to accept the work that she was doing, and she had her own professional indemnity insurance. You would have thought that this would have been an example of a case where somebody was truly self-employed, but no, the employment tribunal decided that she was actually a worker, and she was claiming, for example, discrimination, unfair dismissal, wrongful dismissal. And although the wrongful dismissal and unfair dismissal claims didn't succeed, she had that status as a worker to springboard up to be able to pursue the discrimination claim. And the Employment Appeal Tribunal agreed with her. The Employment Appeal Tribunal agreed that notwithstanding this corporate image of the limited company that had been projected on her status, they found holes in that and decided that she was a worker. So as you can see, it's really caused a whole bunch of problems. And if you take a step back as to what is happening with the changes that are about to come about with IR35 and just wander into what may happen in employment law, there's really a significant risk that if you're trying to say to somebody, trying to say to a contractor, well, you're employed you're an employee for tax purposes, but you're not getting any of these rights, such as holiday pay, pension contributions, sick pay. You can just see on the landscape in the horizon, set against all of these cases that we're talking about, there's going to be challenges. So I think that's how the landscape's set up and how it looks as we go forwards into April 21 and beyond.
Simon, I was just going to add into that as well. I think you're absolutely spot on. We've already seen high levels of union activity, in unionized environments where there's this clash, isn't there, between, on the one hand, some contractors wanting to be deemed outside of IR35 so they get a better take-home pay, but then that can quickly flip around and say, okay, well, if I'm going to now be inside, then I want all the employment rights. So there'll be, in unionized environments, there's probably going to be quite a bit of agitation there, I would have thought.
And you talk about the unions. I think we went back to September 2019, and there was a case in the Watford Employment Tribunal that basically looked at the status of yodel couriers, and that was, I think one of the cases was a recognition case, that in relation to the trade union having some activity. So they're really going to be banging the drum about this as we move forward.
In actual fact, I think that's a really good example, because I've got experience of assisting an NHS trust where the revenue came along and said initially all the locum out of our GPs were employees, but when we dug down and interviewed them and went back with the facts, the revenue actually backed off and accepted they were self-employed, and they were engaged directly, not through limited companies. So it just shows what a minefield this area is.
It's so tricky, isn't it? I think we'd encourage anybody to take advice on it, because even for us as knowledge experts in the sector, you'd think that courts would fall one way, but they go another. So I think there's definitely encouragement to everybody to take advice on any of these areas, because each individual business has a different set of circumstances, and it all needs to be considered in the round. We've seen plenty of examples in public sector where we had some workers who were thinking about their IR35 status suddenly starting to talk about AWR, for example, and you're like, okay, if you're going to start making claims around AWR, you may want to think about the way that you're operating this limited company is outside IR35. So the whole thing's very much linked in, and you can see that it's just going to be a huge, it's going to be a lot of work done by the government over the next 3 or 4 months, or 3 or 4 years rather, to really try and sort of straighten this out, because it's going to be a lot of friction.
Yeah, absolutely. There's going to be more and more challenge as we go through the next few years, if it's not straightened out.
Yeah. We have another question relating, I guess, to clarity as well, and this is for you, so I think, is what happens if the client or the agency or the PSC is actually based offshore? What's the applicability here?
Well, that's an interesting question, because the revenue actually has backed off on this one, because their initial guidance was that even if the end hirer was offshore and had no presence in the UK, they still expected them to operate the rules. Now, they have confirmed that the question is there a liability to PAYE and NI? Where's the work being carried out? What's the residency status of the individuals? But this is another area where people need to be very careful to not get too focused in just onto IR35, because there are other specialist rules, for example, around continental shelf workers, where that legislation again takes priority over IR35. But basically, if they were an employee of the client and the services are being provided in the UK, then it doesn't matter whether the intermediary is offshore. The chances are that PAYE and NIC are going to be due. And in terms of the chain, if there's a non-resident party involved in the chain, then the SDS has to be passed over that party to the next person that is within the UK jurisdiction. So it's important that if person higher up the chain knows that there's somebody offshore lower down before the workers intermediary, that they do ensure that that person does get the SDS and that they are going to operate PAYE and national insurance.
So
just thinking around that as well. If the hirer had no entity within the UK, but the worker was doing the work in the UK, is there still an obligation on that hirer to make a determination? If they were based in the US, for example, would that still be expected?
Initially, the revenue said yes, but they have backed off, because there is a case, Oceanic Contractors, which actually talks about the jurisdiction of PAYE. And if there isn't a trading presence in the UK, then the revenue can't enforce it. I think what probably needs to be sort of considered more carefully, and we're in a bit of a sort of like no man's land because of Brexit, is that there was jurisdiction under the EU rules for other authorities to collect UK NI on behalf of HMRC, but that's a whole different minefield.
Yeah. So in that example, then it would be the old rules would apply. The contractor would still be responsible for determining the status, and they would still carry the risk, basically.
Absolutely, yeah.
Okay, and Dan, I think we have a question come out for you. It's around the comments you were making about the vast majority being assessed and having to be paid differently. And we think that most of those will, the go-to solution will be with umbrella providers. And you did talk about some of the potential pitfalls, but the question is, what sort of checks would you make to ensure that the umbrella provider is reputable?
Yeah, so I think, as I said earlier, I think the starter for 10 would be checking if they're a member of the FCSA as a starter for 10, given there's a pretty high bar for levels of compliance to be part of that association. So I say that will be the starter for 10. I mean, we at Giant, we take quite a lot of comfort actually, where hirers and agencies are asking lots of questions around compliance and sort of checks, and sort of things that we see coming across would be, you know, show us examples of your wage slips, show us examples of your RTI payments over to HMRC. So they're actually trying to see, okay, from the funds that we send through to you, how does that appear on the wage slip for the contractor, for the employee? And then these payment amounts that you've got paying off to HMRC on here, is that backed up by your RTI statements? So that's really sort of as far down that as you can go. I think one of the sad stories off the back of the 2017 changes was the huge rise in non-compliant providers that were out there. And I think we've seen lots of non-compliant activity again this time around, where companies are looking at setting up to try and capture, you know, get workers in who will be tempted by these high take-home pays. And unfortunately, these businesses are really good at window dressing to make it look as though they're operating one way, when in actual fact, it's behaving differently. So we see, or have seen examples previously where there's been one-page wage slip that's presented for an audit purpose, and then there's another actual wage slip or remittance that's actually being sent. So it's really difficult to stop when you start going down that rabbit hole to get absolute certainty that the partner that you're dealing with is operating compliantly. That said, you know, this is a pretty mature market now. There are established players out there. So if you're wanting to hedge your bets, you know, look at balance sheets, look at trading history. Absolutely need to make sure that they are financially stable. I think, as Sue mentioned, there's a potential debt risk going back up the supply chain here on IR35 if the fee payer wasn't deducting the right levels of tax, and HMRC couldn't get that money from them, perhaps because they've wound up or they've gone bankrupt, for example. So a business should take some comfort in the financial standing of that payroll business. So I think simple checks, which you should do anyway from a procurement perspective, of looking at, you know, company's house and the information that's filed, draft an RFP that you might want to send out and get someone to respond back, you know, confirmation of insurance is in place, confirmation of financial standing and processes. I think, you know, we certainly welcome it when we see these checks coming through, because it means that we're dealing with a hirer and a recruiter who, you know, understand compliance, and actually they want to make sure they're not exposing anyone to risk themselves as well as contractors. So if you need some support and help on sort of checks to take place, then, you know, we offer that service as well as other accountancy businesses as well. But I think as a rough, quick check, our FCSA is a great place to start.
Okay, thanks, Dan. One more then from the floor here. If an individual is engaged as self-employed but seeks worker status, presumably they've declared to HMRC that they are self-employed. Are there any issues of illegality that could be relevant to any claim?
I think that's one for me.
Simon, yeah.
Me and Sue, maybe. I'll chip in to start with. I think I follow the question here. I think what the argument here is that if they've declared that they are actually self-employed, but they're trying to seek worker status, for example, in the employment tribunal, could the contract be declared to be illegal, or is that an illegal contract, which would then give rise to them not being able to make that claim? I can see the argument. I have to say, I don't think, bearing in mind the case law that we've seen so far, where people, like, for example, the case that I referred to with the GP, there was no argument that was raised in that particular case about illegality of contract, because they'd held themselves out as being a limited company contractor, for example. that they didn't have any entitlement to employment rights. But again, it's just something else that's adding to an extra layer of uncertainty. Would you deprive these people of those employment rights if they were genuinely found to have been a worker? I think it's facts. Some of the facts, it will be fact sensitive in each particular case as to what was in the individual's mind, what their intention was when they'd made that declaration and were now subsequently trying to seek worker status. But I think it would be dangerous to proceed on the basis that well, the contract will be illegal because they've made a wrong declaration and therefore they won't be entitled to the rights. But that is just my view.
If I can just pick up on that, it's actually quite interesting because a lot of the case law from a tax point of view are people that have been quite happily to be self-employed until something's gone along, and the revenue are very good at making it clear to the individuals what the potential upsides are to get them to support the revenues case in arguing that it should have been employment.
Yep. Okay. Right, good. And perhaps time for one last one then, and may involve all of you again, is do we have to make assessments or can we say everybody is inside? Dan, do you want to kick us off with that?
Yeah, I'll go first on this. So I think that's referring to, if we've heard a lot of noise in the market about blanket decisions on populations of workers, where a hirer may turn around and do a blanket decision to say that everyone is inside IR35. I mean, certainly you could do that, but it would definitely not tick the reasonable care point that Sue's highlighted previously. You know, if as a business you were looking at, if you believe that all your workers were inside IR35, you may want to consider how the banks approached it, which is actually to say we're making a commercial decision moving forward not to engage limited companies. You'll have to go through a payroll provider, or you go on our PAYE or whatever the payroll options would be. But that's a subtle difference, because that therefore means you're not having to do any more assessments because you're not engaging with limited companies, and that sort of circumnavigates the reasonable care argument. I think if you are still willing to engage with limited company contractors, then you absolutely should be doing assessments, which can be role-based assessments, and then you need to start thinking about how you're going to segment the population up and how you're going to operate those, whether it's going to be via the CES tool, HMRC's tool, or one of the other models that's in the market. So I wouldn't recommend anyone to make a blanket decision. It will go down very poorly with the contractors, but it also opens yourself up to some of those challenges from HMRC on reasonable care.
Yeah, Simon, Sue, anything to add?
No, that's I agree 100%. The revenue have actually confirmed that there is a difference between a blanket statement or blanket SDSs and taking the commercial decision. They've also said it's quite okay to make single determinations on groups of individuals, provided they're all engaged under the same terms and conditions. I mean, I think that's one of the areas that I always suggest is when you're looking at using a tool like CEST or one of the other ones that are commercially available, is that you actually get the contractor to buy in to actually complete the questions, and then you look to see if there are any differences in the answers to actually head off any disagreements before it gets to that stage.
Yeah, and I think on the market, I think it's referred to as collaborative assessment approach, isn't it, Sue? So a lot of these tools will actually have the ability for a contractor to have some input. As it starts with a hiring manager, but then it's followed up with some input from the contractor. I think the other thing to mention here as well is that whilst the assessment piece is subject to conversation here, what this quickly does then move on to, if a hirer is looking at everyone determined as inside, is actually it boils down to rates. So and actually an assessment that needs to be done as well as an IR35 assessment, being more practical, is how business critical are these contractors to our organisation. If they're business critical, then if they're determined as inside, you need to be thinking about what you're going to do on the rates to potentially help that contractor reduce the impact on their net pay. If they're not so business critical, then that's obviously a different conversation. So I think it quickly has to move on to think about actually commercially, can we afford to rattle the cages of these contractors? Do we need to consider rate increases? And our experience is the answer to that is yes, hirers will do it, but they'll only do it for the really business critical ones. And that tends to be, you know, maybe 5% of that population max. The rest of those workers will have to sort of feel the burden of the hit of the tax there and sort of work it through. So it's not just about IR35 assessments. You also need to think about how business critical these contractors are, because if you've got them in doing a project, you don't want them walking off. And there was lots of feedback from the public sector about contractor walkouts around this. So
I agree with that 100%, but I would use, in terms of bargaining tools, just bear in mind that the tax and NI liability hasn't changed. It's who's actually having to operate it that's changed. And so, okay, clients might take a more prudent view than the contractor has taken in deciding historically whether it's inside or outside. But if there hasn't been a fundamental change, then you've got to question whether they were operating compliantly under the current rules.
Yeah, agreed. I mean, some hirers would say, well, hang on, why are we picking up the tax bill for this contractor? They should have been paying it all along. But as we know, and certainly if HMRC has said, they believe that 90% of the contractors out there aren't operating in the right way. So it does boil down to, I suppose it does boil down to, you know, how dissatisfied is that worker going to be, and would you consider that as an option? But you know, it's a financial. So I think really for a hire, it's about trying to figure out your appetite for risk versus that financial cost and where you are on that spectrum, and that will be different for different businesses.
Yeah. Okay, thank you, and thank you all. I'm sure everybody's hanging on and dying to know what happened with our poll. So let me give you some insight into that. The great news is for you three guys speaking is that when we started, there were 59% had a reasonable grip on this, reasonably confident that they could manage it. That's now gone up to 80%. So I think you've obviously cleared it up very well for some. A couple of interesting questions on the other 2 points. That we had 6% who were very confident, and that's dropped down to 5%. We've probably given them a little bit more to think about. Maybe they've dropped into the reasonable and they're still in control. But the not confident at all was initially 35%, and that's dropped to 15%. So that's again a good result. That 15%. You better stay behind and do some extra homework, but I'm sure you will move up that scale over the next few months, and these guys are around to talk to you if that would help. So thank you, and that's all we have time for today. Many thanks to our speakers. They've had a good grilling, and to you all for your attention. We trust it's been very worthwhile. Thanks for doing that poll. And let's look forward to a successful implementation for you all. We will be following up with an email which will contain a link to the discussion and recording. We'll have a quick questionnaire so you can let us know how you think we did, and there will be the contact details of the speakers, as I said. We will respond to the themes of the questions, and there's 1 or 2 that we didn't have time to address, which perhaps we can pick up on as well. So that's it. Thank you again. Have a great day, and thank you. Thank you. Bye.